books and more than 600 papers and conducted research on the malleability of human memory. As well as her work inside of the laboratory, Loftus has been involved in applying her research to legal settings to our field. She has consulted and provided expert witness testimony for hundreds of cases. Professor Loftus is best known for her work in the misinformation effect, the eyewitness memory, and the creation of false memories, including recovered memories of childhood of sexual abuse. She is a member of the National Academy of Sciences and Fellow of the Royal Society of Edinburgh. Professor Loftus, the floor is yours.
Thank you.
Thank you.
Yeah, thank you so much, everybody. Thanks, Anat, and the public defender in the District of Haifa. Thank you, Meital, and all the District Attorney's Office in Haifa. And of course, thank you, my dear friend Yoram, Justice Danziger, heading the committee and doing a wonderful job. I know that we wouldn't be able to produce two reports in such a short while time without such a great chairman to the committee. But thank you more than anybody else, of course, Professor Loftus. Most people here, the 205 now, 205 participants.
Wow.
Yeah, attending this event now do not know that we surprisingly woke you up at 4 o'clock in the morning, 4 a.m. in the morning. We truly, truly apologize for this mistake, and really, really thank you for your willingness to do it at such a, despite this huge mistake. And maybe few words, or without further ado, I'll start some of the questions.
Go for it.
Go for it. Okay, so the first excuse for this meeting was the first interim report of the committee, which dealt with eyewitness misidentification. And I would like to start with this topic. Probably we'll go over other topics later on. It's interesting to see how 3 cases in the last year and a half or 2 years where defendants were acquitted in Israel, either on the appeal after being convicted in the first instance or in the first instance, where when the judges basically decided that the identification was false because they saw the CCTV video that the identifier saw. So the story was that either a police officer who knew the suspect or the mother of the suspect in another case identified the person in the CCTV video. And then when the judge looked at the video, he said, nobody can be identified that way, and acquitted the person despite the indictment. What makes me believe that obviously if there was no CCTV in this case, there was no acquittal. So if the person was there and said, I saw it, and we didn't have a video of what he saw, probably these people would have been convicted. But more interestingly, I thought maybe it's not only or not mainly a matter of memory, because if one person identifies the suspect and another doesn't identify based on basically the same video, then maybe the problem with eyewitness misidentification to a large extent is not a problem of memory, but a problem of identification. Can that be?
Well, I have to say, I've never been asked that question before. It doesn't really make sense to me to say that this is not a problem of memory, because you have an event, some bits and pieces of experience are going to be stored in the mind of the person who saw the event, and they're going to later on be asked to retrieve that information from memory by answering questions or testifying or taking or making an identification. Those are all different acts of memory retrieval. So it seems like it's a semantic quibble that is not going to really advance us to wonder, is it memory or isn't memory? Do you know what I'm saying?
Yes, but what I thought is that since in this case, you could have looked at the video as many times as you wanted. Everybody could have looked at the video as many times as he wanted. And still there was a failure of identification. It seems that part of the issue, at least, is not memory, or that's my hunch here.
I'd have to see that video, because I suppose there are all kinds of reasons having to do with disguises, you know, a difference in appearance because it's an older video and the appearances. There could be a lot of reasons why somebody doesn't get recognized from a video that caused that to happen.
Another thing that we found during the meetings of the committee was that the police members of the committee told us something that shocked us, and maybe that was the thing that made most of the headlines when we published the first interim report, and that is that 25% of the lineups that they conduct, in which the witness point to someone. I'm not talking about the 50% of the lineups that nobody is pointed at, but in 25% among those cases where the witness pointed someone, they point at someone that is not even a suspect. They pointed at one of the I forgot the word.
Fillers.
The fillers, yes. One of the fillers. Exactly, one of the 5 fillers in the usually photo lineup, which of course means that at least 25% of the cases there is a misidentification. The question is whether there is a procedure that can reduce at least the cases of false positive. I'm not talking about false negative now. But is it only a matter of procedure? Is there a way to reduce the number of false positive to near zero?
Well, first, let me comment on the data that you're presenting, because there are now quite a few of what we call archival studies, where you go into a police department and you analyze all of the, let's say, the lineups or photo lineups that have been done, you know, over the last 2 years, whatever period it is. And yes, we know from those archival studies, and the one you described just adds to that collection, that real witnesses in real lineups frequently pick somebody who is a filler or a foil rather than the suspect. So these are known false identifications. And that's why I think, to some extent, the police are a little more receptive to the idea of reforming procedures to reduce this kind of event, because they see those mistakes more often than, say, prosecutors. In that original committee that was composed of prosecutors, police, defense attorneys, and some others, scientists who were trying to reform the system and reduce the rate of wrongful convictions, the police were much more receptive to the idea of implementing reforms. And then we can talk about, okay, what should those look like?
Mm-hmm. Yeah. And do you have some insights about the possible reforms? I know we thought about some in the committee, but were very, most of them were debatable. Some of them were objected by the police, but at the end, is there something in the current literature that would suggest better procedures?
Well, there are a number of recommended reforms some of which are included in that executive summary of your work that I had a chance to look at a week or two ago. And so there are things that can be done, for example, at the time of the identification test, or at the time of the lineup or photo identification. One of the best procedures is to have blind testing, or sometimes called double blind testing, where the person who's conducting the test does not know who the suspect is. If there were one recommendation to be made, it might be that one. And the reason for that is you don't want the investigator somehow cueing the witness as to who the suspect is. It can be a subtle cue, but you don't want those even subtle cues to indicate to the witness who the suspect is and have the witness simply comply with what the witness thinks is the investigator wants. But there's also another reason, and that is sometimes after an identification is made, the witness will say, did I pick the right person? And you don't want the investigator to say, yes, that's our suspect, because that kind of post-identification feedback is going to mess things up. It's going to make the witness more confident than they would have been otherwise, therefore make them more impervious to cross-examination, more impressive to a jury, and more likely to lead to a conviction as a result. Well, if you have blind testing and the investigator, can honestly say, I don't know who the suspect is, then you're not going to have that feedback problem. Now, I've had police contact me and say things like, we have a very small agency here, and we don't have the manpower, person power to bring someone else in and have the testing be blind. But I think there are other ways to get around that problem and to be able to do it in a blind fashion.
Professor Yonatan Goshen from the University of Tel Aviv wanted to ask you, I think, exactly about that topic. Yonatan?
Hi, Elizabeth.
Hi, how are you?
Hi. So just a follow-up and about the double blind procedure that I had a chance to talk to you about. I felt a bit uncomfortable with the strength in which the committee made the recommendation. So the committee did say it's much better to do double blind study testing, but the police said this is really, really difficult. And as you said, we don't have the resources. Now, to my mind, the government in Israel is one huge financial resources, and they're going to be losing at the other side by having wrong convictions. So maybe they're saving money by not having that additional person doing a double blind study, but it's going to cost them that much more getting the wrong people. And would you somehow agree with that? Do you think it may be a bit extreme? Because to my mind, they should really get this particular aspect right.
Well, I agree, yes, that the double blind recommendation is an important one. And, I think that maybe we can figure out some ways that possibly it doesn't involve having to use a different person. Maybe there's a procedure that gets set up and nobody is in the room with the witness when they're looking at whatever they're looking at. And anyhow, I think we can work that out and still strongly encourage a double blind procedure and try to address the concern that those smaller agencies have about resources.
Sorry, I'll just say in defense of our committee, if I may, we did recommend double blind, but I agree we didn't recommend making any other procedure inadmissible. The reason was that the police objected and said it's not always possible. But I believe that by making this recommendation and clarifying that it is much more reliable when it's double blind, We gave a very significant incentive for the police to do it double blind. Otherwise, obviously, the defense will be allowed to waive that. Look, the committee recommended double blind. It wasn't double blind. You shouldn't trust it as much. I think this idea, together with data of 25% false positive mistakes, at least 25%, will make it less likely to happen often. But yes, running a committee also needs us to make some kind of compromise sometimes. And that was one of them. Other issues, by the way, we were much less certain about, for example, whether to show in the lineup people one after the other or together. At the end of the day, we recommended that we will stick to the to showing all the photos together, based on what we thought was more reliable in the literature. But maybe you have another view on that.
Well, you know, for a long time, you know, a couple of decades, particularly Gary Wells, who's of course a major contributor to the science of eyewitness testimony, was recommending this sequential method of showing photos as opposed to the simultaneous method that was more routine. And he certainly had a good theoretical reason for introducing the idea and advocating for the idea of the sequential lineup. His theory was that you want to minimize the chances that the witness is going to look at the photos and say, well, that one's the closest, or in other words, make a relative judgment. That one's the best, better than the others. That's not the kind of judgment you want these witnesses to be making. So the sequential method was thought to reduce the use of that strategy on the part of a witness. Then some newer work with slightly different statistical analyses came out that started advocating for the simultaneous method. And things did get a little heated over here. These scientists duking it out at conferences and duking it out in the pages of scientific journals. And, you know, I think when the National Academy of Sciences did produce its report identifying the culprit, which I would imagine that maybe many of you have seen, 2014 report, they just remain neutral about this preference. And I think that's sort of where things stand today.
Yeah.
You don't see people pushing one method versus another.
So let's move on a bit from eyewitness identification to other memory issues of eyewitness. It's interesting that in the mandate of the committee, the minister asked us to give recommendation about problems, about false convictions that might result from either eyewitness misidentification or eyewitness testimonies. That was in the mandate. And we thought a lot about it. What should we do with regard to eyewitness testimony? What we call event memory, not face memory. And at the end of the day, after discussing it much, we didn't come up with anything. And the report doesn't really refer to the problem of event memory problems, because we simply didn't know what to do with it. Not that we didn't know that there is a problem, we know there is, but we didn't know how we can solve the problem in any recommendation. And my feeling is that if we put aside, of course, memory altogether, we cannot have a trial. That's not an option. But that there's no real consensus about how we can reduce the risk of false memory affecting trials. Do you have any ideas of what can be done on this front? It's a big question.
Yeah. Excuse me. the kinds of reforms that might be suggested are things that, say, the police can do at a lineup. Is it double blind? What kind of instructions do you give to a witness before they try to make an identification and so on? But there are also other reforms, things that can happen at a trial. And even the National Academy report that I mentioned earlier talks about having an education of jurors or the trier of fact. So how do we do this education? Either through jury instructions, where you can educate people about the nature of memory, about the factors that influence memory, or sometimes through expert testimony. And I think that this National Academy report embraces both of those different forms of education. So if you want to educate people who are going to be making these decisions, presenting them with scientific findings about how certain factors affect memory, hopefully they will use that information to arrive at a better decision, to scrutinize the memory and not simply accept it because it's offered in a confident and detailed fashion. And I mean, I think that would be a step in the right direction.
Jonathan, you wanted to add something?
Yes, I think I would add something, and it derives directly from Elizabeth's lifelong research, but has applicability to police lineups. And I'd like to hear your reaction, and that is to make really sure that there's no contamination in the process, because really a lot of Elizabeth's work has to do with eyewitness contamination. That's how she started off her history in applied research. But make sure that nothing gets contaminated, that there's no information, no verbal information, no pictures. Same applies to lineups. Let's make sure that the witness did not see any version of the picture. Now, in the recommendations of the committee was very strict to make sure there's no correct recommendation. And then towards the end, had unfortunately slightly slipped up and said, well, listen, in certain situations, what can you do if they actually saw the face? So again, I understand that there's lots of pressure within a committee, but I'd like to hear Elizabeth's opinion about contamination, about seeing that face for the first time versus not for the first time. That's how I would phrase my question.
Okay, I want to move a bit from the eyewitness lineups, but take what you said about the contamination as one of the solutions to the problem of memory problems, but also two suggestions that Elizabeth gave, jury instructions and expert witnesses. My feeling is that the three solutions that you just mentioned do not really solve anything, because at the end of the day, we have to rely on memory in deciding the case. So we don't have jury, so jury instruction won't help. We can do, judges' continuous education programs, and we do that, and bring researchers to judges to learn about the topics, that's fine. But at the end of the day, what judges have is memory. Sometimes it's contaminated and we don't know that it's contaminated. Of course, if we do, it's easier. The problem is in those cases where we don't know. And my feeling is that we couldn't really give any proposal to confront this problem of memory contamination or fault memory, which is not with regard to eyewitness identification.
Well, I'm not going to be able to solve the problem.
Yeah,
problem for you. I will say that the state of New Jersey in the Henderson decision did produce a set of jury instructions that I thought were magnificent instructions in terms of educating people about the nature of memory. When those Henderson instructions were put to study, it was found that what they do is reduce the embracing of the eyewitness. They make it less likely that, let's say, less likely that the eyewitness will be kind of automatically believed, accepted, and result in a conviction. But what they don't do is allow the trier of fact to discriminate between a good identification and a poor one. So I think we need more research, maybe tweaking those New Jersey instructions to get to the result that we would really like, which is that jurors should be, hopefully be able to know, they'll never be able to rely, 100%, of course, but to be better able to discriminate a good case from a not so good case.
Okay, I think Rotem, the committee's coordinator, wanted to ask something. Rotem, are you here?
Yes. Hi, can you hear me?
We can hear you, and probably when I'll find you, I'll also be able to see you.
Hi, so thank you, Professor Loftus. Thank you, Oren. So I wanted to ask concerning memory contamination, and also with regard actually to police lineups. I was very interested in the point you made about the importance of not providing the eyewitness with information about whether or not he or she actually managed to correctly identify the suspect. And I was wondering whether what you're worried about here, that this confirmation might somehow contaminate the memory of the event. And if so, I was wondering whether this could be applicable maybe to other sort of police procedures or things that the police should or shouldn't do, so that the court can later be provided with a reasonable or account from the eyewitness to prevent memory contamination.
Well, yeah. So the fear about this feedback, and it could be feedback. It has been studied, giving feedback about an identification, but logically giving feedback about any memory aspect that people utter is going to artificially inflate the confidence level. And that's a problem because it makes that witness more confident when they express their memory in court and more likely to be accepted, embraced, and followed. Feedback can be not only you pick the right person, but feedback could be a piece of information that acts like feedback. So if the police are saying, well, yeah, we found a fingerprint, we found the guy's fingerprint at the scene, or some other piece of evidence that can do the same thing, which is artificially inflate the witness's confidence about their memory. So you really want to avoid all those different forms of feedback. And of course, people are now recommending that you get that initial confidence from people. You get that initial confidence right at the time, so that if it inflates, at least you know that at one point it was less, and you can start to ask what happened in between, and maybe start to look for potential contamination that might have gone on.
Yeah, one of the recommendations, of course, of the committee was that the police officer will write the confidence immediately after the identification, exactly because of what you just said and because of your research, I must say.
Right.
And that was part of the. While
we're at it, let me just say, there are some people over here where I am at 5 o'clock in the morning, who are saying that, if the initial confidence is high, that's all you need to know. You can just embrace the eyewitness testimony and accept it, and it's going to be right. But many of us think that that is an overstatement, and that there are times when people will be initially fairly confident and be wrong, because sometimes the contamination has occurred even prior to the lineup or during the lineup.
I can tell a story of mine. When I was in New York in the Village with my then wife and friend, and someone got into the pub and stole her wallet from the bag. Her friend and I saw him. I was stupid enough to run after the person. And only when I got to him, I understood it wasn't very wise to contact him. So I said something like, sorry, I think you mistakenly took my wife's wallet. He looked at me differently and went away. But the story was that we were then took to the NYPD. And she was asked, her friend and I said we couldn't identify her because we knew our disabilities, but she thought she can, and there was a mugshot, and she was asked, can you identify? And she identified someone in the mugshot. And the police officer told her, so how sure you are? And she said, I don't know, it looks like him. And he said, I need you to tell me it's 100% sure so I can arrest him. Now, she at that time studied with Phoebe Ellsworth in Michigan, law and psychology, and said, oh, you shouldn't do it like that. He said, Mrs. Do you want to help us or not? So, yeah, there was no arrest that day.
Well, that's just it. Sometimes, they're very well-meaning, and but they can do things that are not right from a scientific perspective. In one case in which I testified here in California, the eyewitness was shown a six-pack and was not picking anyone, and the officer said, "I see your eyes drifting down to number 6. Look again." And fortunately, that for some reason that was recorded. So we had a recording of the officer doing exactly that. I don't think that officer was really deliberately trying to produce a false identification. He thought he was just, responding as a human, but it was not a good practice.
Exactly, and recording sometimes can help here, and not always. As Jonathan said, contaminations like that can happen all the time, and we don't know about it by the time we get to court. Maybe we'll move further to something even a bit more sensitive. So if you take the fifth for this question, please do. I don't know, I thought whether I should even ask it or not. But in many sex offenses cases, the debate is about consent. And I don't want to talk about the cases, when the defendant say that the victim is lying. That's not the questions that I'm wondering whether you believe that issues like willingness and consent in sexual relations can be amenable too. I mean, the memory of that can be mistaken by any of the parties, by the aggressor or by the victim. Can one of them agree and then say he didn't agree, or vice versa? Knows at the time that he attacked the victim and afterward really believe that he didn't?
Well, there are different kinds of cases involving sexual crimes or sexual accusations. For many years, we had a huge rash of these repressed memory cases where somebody comes in and says, I was molested as a child and I repressed my memory, and now I have my memory back. And they bring the accusation forward. I actually testified in one such case in Israel. The problem in these cases is that many times there's some highly suggestive psychotherapy that has intervened between the childhood and the adult accusing person. And this highly suggestive psychotherapy might involve guided imagery. You don't remember any childhood abuse. Why don't you close your eyes and try to imagine who might have done this? Giving these patients suggestive information that probably they have buried trauma memories that need to be dug out, recommending books to them that advance this repression theory. So these are examples of suggestions that have led to a number of false accusations. What happened after we saw lots of these false accusations is some of these patients actually started to realize that their memories were false. And they then sued their former therapists for planting false memories. And there was a rash of successful civil cases where these patients got judgments or settlements against a therapist who had been accused of planting false memories. You know, in the current Me Too environment, you don't necessarily see claims of repressed memory. As you indicated in the wording of your question, it's often people who one says it was consensual and the other says it wasn't. So whatever happened, whatever happened can be distorted by post-event activities. I've seen situations where an accusing person is confused about what happened, tells a friend, the friend says that's rape, that is labels it rape, and now the event is remembered in a more aggressive, more inappropriate, more uncomfortable way than it would have been otherwise. So that this is another example of how post-event contamination can affect the way an event is reconstructed. And, you know, and it might be that, you know, the accused person can have some memory distortion that, you know, a motivation to remember it is more consensual. We can't rule out that concern as well. But, you know, I see the cases that get litigated. I see the most contentious cases, the ones that end up in court. So the most disputed cases. And so I may be seeing a special subset of cases in my experience as a scientist who occasionally gets involved in court cases. And it's possible the therapists are seeing a larger category of situations, including the ones that are more clear-cut.
Yeah, thank you. Maybe I'll move to the third topic of our committee, the topic that we just started discussing. So the first topic was eyewitness testimonies and misidentification. The second one was forensic science, and we just started last week discussing false confessions. And the issue of false confession, usually when we discuss false confession, we discuss police-induced confessions, whether they can be reliable, when and where. But more and more scientists argue that there's also internalized confessions. People really believe after being interrogated, really remember what they confess to. How serious is that in your view? Can I really plan through police questioning a memory of committing a serious offense, I'm talking about, in a suspect that way, in a way that he will not only confess, but also believes that this was done?
Usually I'm going to defer to the false confession experts. Somebody in this group mentioned Saul Casson. He's a great one. There are a few others who really specialize in false confessions. And my reading of their literature is that occasionally you get this internalized false confession where the person really comes to believe they did the crime, as opposed to some other process going on where they don't really believe it, but they see that saying it is the lesser of two evils. But I'm most interested in those internalized ones because they overlap with the false memory work.
That's why I asked you about it.
Yeah, and so I would just direct you to the Canadian study that was published a few years ago, where some of the same highly suggestive techniques were used to get people to remember committing a crime as a teenager that was serious enough that the police actually came to investigate. And this these Canadian investigators published their work in one of the top journals, reporting that they were successful with about 70% of these ordinary, healthy human beings in getting this false confession to a completely made up story. Now, I will say that some other investigators were so shocked at that 70% figure. Really, it's that high that you could get with a few suggestive interviews, 70% of people to confess to having committed a crime as a teenager? And so they reanalyzed the data, the Canadian data, and they thought that the Canadians were a little bit too liberal in classifying something as a memory. And really the figure should be, closer to 30 or 35%. So that's all laid out in the literature. But my reaction to that is even if the figure is 30 or 35%, it's still pretty impressive. And that's an example where people were actually led to essentially, usually they weren't super serious, but they could involve some physical touching or pushing or graffiti or something like that. But still, that's a clue that, yeah, you can get people to believe that they did something that they didn't do, not just that they saw something that they didn't see.
Okay, one last question from my side, and then we have questions from Anat, Meital, and I think Igal Balfour also asked in the chat to ask a question. If someone else want to ask something, please write in the chat. One big debate between the prosecution service, between the state attorney and the defense attorneys is with a pre-testimony interview of witnesses. So the story is a witness is supposed to testify tomorrow. It has already been 2 years since he gave his testimony in the police. And he's invited to the prosecution service office for helping him recall what happened. They are allowed by their internal guidelines, published guidelines of the prosecution service, to show them what they said in the police, to show them the written testimony in the police. And show them other documents as long as these are documents that the witness already have seen before, either in the interrogation or during the regular course of action. And even more debatable is they are not allowed, of course, to say, the defendant says that you attacked him first or something like that. But they are allowed to tell him, assuming someone will claim that this and that happened, what would you say? And the guidelines allow that. The prosecution service says it's a must because these people forget things after so many years. We must show them what happened and we must prevent them from being surprised in court. On the other hand, the defense attorney is saying this is suggestive. What's your take? Any take?
Well, I can certainly see why the prosecution wants to do this, because what they're going to be doing is helping to create witness testimony that is more fluent, more articulate, expressed probably with greater confidence, and more likely to be accepted and believed by the trier of fact. That's going to be a consequence of that kind of procedure. You know, so is that fair? Is that not fair? I mean, it's, you know, as somebody else has to make that decision. But that's likely to be the outcome of that kind of the preparation. We also know that, for example, if speech has a lot of hesitancies or verbal hedges, things like, it seems to me, well, I sort of remember, that it's going to be less persuasive. That kind of preparation is going to reduce those kinds of verbal hedges and again make the witness a more compelling witness. And I'm not sure who in our society should be the one to make the decision about, is that fair to the defense?
Currently, by the way, it was argued in the court, and the Supreme Court approved the guidelines. So today in Israel, it's legal. But it's still heavily debatable. There was one district court that required a recording of this kind of preparations, but it was overruled in the Supreme Court.
You know, sometimes things are allowed that aren't necessarily a good idea. I mean, I don't know, over here, for example, the police can lie to a suspect in order to get a confession. They can say a witness saw you when it didn't, or you flunked the polygraph, or, you know, whatever, in order to try to elicit a confession. That's exactly the kind of thing that we do to create a false memory. We lie to people.
Yeah, it's true here also, at least for now. And now I'll open the floor, and first to Meital, one of the organizers, the one from the District Attorney of Haifa. Meital, you have a question?
Hi, Professor Loftus. Continuing from the point of the prosecutor's point of view, at the stage before deciding whether to indict an indictment, which precautions, guidelines, warning light that we should notice, that we should be aware of, you suggest us, again, as member of the prosecution, to take when we examine a testimony of a victim of sexual abuse that occurred many years ago? How can we distinguish between a memory that is recovered and true than a memory that is implanted and false?
Without independent corroboration, you're not going to know for sure whether you're dealing with an authentic memory or one that's a product of some other process. I mean, when I get involved in court cases, I'm looking to see whether there are examples of suggestion that could be responsible for a distorted memory or one that even is entirely false. So you might try to just explore whether there are any sources of suggestion that might have influenced this memory. What kind of media coverage was the person exposed to? What kind of conversations did they have with other people? What kind of psychotherapy? And what were the processes involved in that psychotherapy? These are some of the things that have led to what I believe are possibly, or maybe even probably, distorted or false memories.
Thank you.
Okay. Anat, you wanted to ask a question?
Yaniv will be asking on our behalf.
Okay. So Yaniv.
Okay. Yeah, following Meital's question, has there been any change or trends in the following years regarding the memory wars, i.e. the argument between memory that was suppressed and therefore retrievable by various methods, or one that has been implanted? Has there been any trend of change in the last couple of years?
Yeah, I'll tell you kind of what I see, sort of a bigger picture. We have the Me Too movement, and it's a movement of, you know, that has some good aspects to it, to, you know, kind of focus attention on some of the bad behavior that has gone on in the workplace and other situations, and that we're hearing stories, some of which need to be believed. But the Me Too movement has also been one that, you know, is believe the accusers almost under every circumstance. And so that has led to contention. Sometimes it plays out in campus sexual assault cases, where you've got one student accusing another student of sexually inappropriate behavior. We now have probably, I'm told, at least 400 cases where punished male students are now suing their universities and colleges for wrongful punishment, based on an accusation that was uncritically accepted and believed, but is being denied by these mostly accused males. So there's a lot of contention that's still going on, even though it's being played out in slightly different types of cases.
Okay, another one about memory. In one of the publications, you wrote that memories are reconstructed, not replayed. Now, is time a key player in this reconstruction, or is it the witness's personality? And if it is both, do we have any means of knowing which of the two contributed more to the witness' alleged recollection?
Your question is making me think about the question of individual differences. Are some people more susceptible to suggestion and contamination than other people? And yes, we have found individual differences. So for example, people who are somewhat low in cognitive ability tend to be a little more susceptible to contamination. People who are particularly cooperative people, and especially if they're a little low in cognitive ability, are a little more susceptible. These correlations may be statistically significant. If you're into correlations, they might be on the order of like 0.3 or so, not overly overwhelming. But really, I would say that most people are susceptible to this kind of contamination, no matter how educated, experienced, or intelligent that they might be. We published one study recently where people with highly superior memories, there are people among us who remember just about everything they did every day of their adult life. They're extraordinary, and they've been studied by some neurobiologists on my campus. They've been featured in news programs. And we thought, well, this special group of memory people, you know, maybe they would be resistant to contamination. But when we put them in through some of our experiments, they were just as susceptible as the age and gender matched controls. So again, even people with really good memories are susceptible to contamination.
Thank you so much. Rabia, you wanted to ask something? 1 minute, I'll put you on mute. Yeah, please unmute yourself.
Hello, Elizabeth. Thank you very much for this really interesting interview. I'm familiar with your work. I wrote a little bit about it, and I think it's really a truly amazing bulk of research, which has really contributed a lot to my own thinking, and I think also to other scholars in Israel. I actually want to ask you about, it's a more personal question about your decision, as we lawyers say, to descend into the arena and to take the stand and serve as an expert witness for defendants. If you don't mind sharing with us your feelings, your considerations, because in doing so, you are actually taking personal risks. You are you're repositioning yourself from a respectable, neutral scholar to someone who's actually taking a side, attracting perhaps some public criticism, making you a partisan party or partisan side rather than just a neutral scholar. So it is a brave choice, a brave decision, but it also comes with some price. And I was wondering if you could share with us your thoughts about it.
Sure. Well, sure. I'd be happy to. The first time I actually had a major struggle about whether to become involved as an expert witness was in the case of John Demjanjuk. And as of course you all here know, that he was accused of being Ivan the Terrible at Treblinka. And I had relatives, you know, who said, don't let this be the last thing you do before I die. I wondered, maybe he's innocent and I should do it. But what if he's guilty? And I just spent months and months trying to figure out what I should do about this request to be an expert in that case. And it seemed like the consistent thing to do would be go ahead and give the science, just like I had done in other cases. But I was just so troubled by, you know, my ancestry and this whole decision. And finally, I was having tea with a friend, and I said, and struggling with this, the consistent thing or not. And my friend said, consistency is the hobgoblin of small minds, quoting Emerson. And I thought, yeah, who says I have to be consistent? There's no rule that says I have to be consistent. And I recommended another expert to the defense. I actually went to Jerusalem and watched that other expert testify. And that was my resolution in the Demjanjuk case. So jump ahead now to Harvey Weinstein. Shortly after Weinstein was accused by a number of people, I got a call from his attorney, his California attorney, a woman I had worked with before, a really smart, clever, terrific lawyer. And she said, would you consult on this case? And I agreed to do it. This could be fascinating. Let's find out. Well, nothing much developed in California, but a year or more later, things were developing in New York, and he was going to be prosecuted in New York. And by that time, there was a massive amount of media coverage about Harvey Weinstein and other accusers. And I thought, this is kind of an icky person. I'm just not sure I want to do this. And so I thought of my Demjanjuk solution. I'm going to recommend another expert. That worked out for me in that other case. So I did recommend a collaborator of mine. She's a professor at another university, and they met her, they liked her, they hired her. And I thought, okay, good, I'm off the hook here. But then Harvey Weinstein spoke to Alan Dershowitz, and Dershowitz said, you got to have Loftus too. And so Weinstein goes back to his attorney, says, I want Loftus too. Dershowitz says, I got to have Loftus. And now what do? Do I back out and why am I backing out? I'd be backing out because I've been seduced by the media coverage, which I have been yelling at people for decades not to let that happen. We can't let the media decide who's guilty and not, or not. And I would be backing out because I feared that I would be hurt in the process, that it would hurt my ability to help other people in the future. And I would feel like a coward if I backed out for those reasons. And so I agreed to go to New York and testify. And I'm now facing the backlash, some of which was described in an article in the New Yorker magazine about a week ago. New York University canceling a scheduled lecture that I was, this prestigious lecture that I was supposed to be giving, even though the airline tickets had already been purchased. A colleague, a law professor, accosting me at the buffet table right before a law school faculty meeting, screaming at me, how could you, Harvey Weinstein, how could you? Some law students trying to get me, the law school, to fire me and not allow me to poison the students with my bad ideas. And so I'm facing the backlash that I knew would happen, but at least I don't have to feel like I was a coward.
Well, I feel often like a coward, but that's another preference. Yigal, please. Yigal from the Defense Attorney's Office.
Hello, and thank you for the lecture. You talked earlier about identification procedures such as lineups, but often as lawyers in cases, we see cases where there is no procedure per se. There is no witness who's being shown a lineup, but just a witness saying X did it. And we know that if the witness knows X enough, meaning his close friend or relative or something like that, we can be sure that he accurately identifies him. Sorry, but on the other hand, if there's no enough familiarity between the two of them, there can be an unconscious transference, meaning that the witness can be wrong and mistakenly thinking that X did it, but it's actually someone else. And my question is, when do we cross the line? How much knowing person is enough to identify him without being done a procedural such as lineup?
I don't think there's one answer to that question, but I do agree with you that people are making identifications in situations that don't involve any police procedure at all. Sometimes it's in social media. One of the cases that was the companion case to the New Jersey Henderson case that I referred to earlier in this conversation, was a situation where a woman is assaulted and her husband comes home and says, I think it was my ex-girlfriend. So they go on Facebook and they look at photos of the ex-girlfriend, and that's the person who ends up being identified. No police procedure. The witnesses are doing this all themselves. And I'm not sure that there's one idea for, some intervention to reduce a mistaken identification or mistaken memory in these kinds of situations. And I don't have some, nice, tidy little rule for you.
We have two more people. First, the one that really saved us and saved the day, Rich, who found the mistake about the timing that was almost ruined the whole event. Rich, please.
I don't have any questions. I'm just enjoying listening to Elizabeth.
Okay,
As I have for 40 years. She's been a mentor to me since I was an undergraduate. And I just happened to live in Israel. She just happened to invite me. And I just happened to note that it was told to her as if she lived in the East Coast.
Well, while we have you, Rich, why don't you just mention your new forthcoming book?
Okay, well, if you insist.
Go ahead.
I'm a lecturer at Yad Vashem, and my specialty is using films, Holocaust narrative films, in the classroom. And I have a book coming out in a month called Holocaust Cinema Complete, which covers 400 Holocaust films and the entire history of Holocaust films. And I live in Kadima, and I'm happy to come and talk to any of you about Holocaust films and memory.
That's great.
Yeah, yes, sounds really interesting. Yes, Jonathan, please.
Hi. So I'm going to try to push one point now that it's question time. I'd like to talk about high confidence identifications. So both Oren and you were laughing at the possibility of contamination. And I'd like to make 2 points. First of all, contamination can happen in any forensic piece of evidence, including DNA. And we don't laugh in DNA saying, well, there could be contamination. We have to be very careful that there is no contamination. And I would like to push the point made by others, by John Wickstead, that we can be very careful with witness identification. It does not have to be the case that there is contamination. And therefore, we can use 100% confident identification. Specifically, this only requires 2 things. Let's not advertise the face of the supposed criminal in the newspaper or in social media. In other words, nobody can see who that person is. Let's not make that face available. And let's not show the witness mugshots of gang groups. So there is no way that the witness saw that face. If that witness comes now and points to a person in the lineup and says, I'm 100% confident, there is no confidence, there is no contamination, there is 100% confidence, and there's not one known case of DNA exoneration where that happened, where with 100% confidence, that person was later found guilty. So the evidence is so strong for 100% confidence if it's the first case without contamination. And I am pushing that for the defense.
Do you agree?
Sorry, for the prosecution.
No, I don't.
Sorry, for the prosecution.
I don't agree.
For the prosecution.
Okay. Jonathan, I think it's clear, yeah. Yes.
Well, first of all, it may be the case that if the initial memory report is expressed with a high degree of confidence, that it's more likely to be accurate than if it's expressed with a low degree of confidence. However, even the high confident witnesses have sometimes quite a significant probability of being wrong. Maybe it's 20% of the time or 25% of the time in some studies. And so you do have to worry a little bit, even if that initial identification is uttered, or expressed with a high degree of confidence. So that's where I, kind of depart from the typical Wickstead position. Also, the DNA exonerations that were written about by Brandon Garrett, the law professor at Duke, who wrote a book based on the first 250 cases from the Innocence Project, the DNA exonerations from the Innocence Project. We don't have full information from that book, from that report, about what initially happened with those witnesses.
I must say that as a matter of practical, it doesn't really matter because we can never know that there was not even a minute contamination that the witness never saw, and therefore we can never be sure that when it was documented that he was 100% sure after the initial identification that it was the initial identification and that he was 100% sure. And then we have some doubts anyway, as a practical matter, not as a psychologist, but as a lawyer. But the next ask, Nili, please.
Hello, thank you for this lecture. It was fascinating. I'm Nili Finkelstein from the Justice Department, the Legislation Department in the Ministry of Justice. I'd like to follow up also the last question and also your explanation about the interviews that the prosecution make. And I'd like to ask you and understand a little better your explanations about the effect of the interview. What I understood from what you said is the effect on the witness's confidence. And I'd like to make a difference and understand better the effect on the confidence as opposed to the effect on the actual memory. And another question, which I think is connected, you also explained how contamination affects the memory and suggestion affects the memory. And I would like to ask maybe a theoretical question, but if you can explain the actual process that the memory goes through without the contamination, if I was clear.
When I thought about what was the likely impact of, let's say, that witness preparation, I think it's an empirical question. We could actually design a study and even get an empirical answer. But in the absence of having that, just given what we know about memory, if you rehearse your memory, you can be more, in some sense, more articulate. You can minimize the use of verbal hedges and expressions like "it seems to me" or "I sort of feel." Those kinds of verbal hedges are associated with less acceptance on the part of people who are hearing the testimony. So I believe that this kind of witness preparation is going to tighten up the language and make the witness appear to be more confident and more fluent and more influential to people who are listening to that testimony. I think that's a very likely outcome of that kind of preparation. So that's, of course, what people want to see happen who are doing the preparation. And I know for myself when I'm meeting with a lawyer to prepare to be deposed in a civil case by an opposing attorney, that in some sense I'm practicing with the lawyer that retained me what it is I'm going to say is my opinion, and that I'm going to be able to express it more fluently and more easily. So I could even sort of experience that for myself in that kind of situation. So that's a likely outcome of this kind of preparation.
May I? If I may, Owen, I would just like to articulate. I feel like your claim might be more effective against what in Israel it's a judge, not the jury. What process he does with this, how the witness actually speaks in court. But my question is, do you claim that it actually also affects the memory? I mean, I would like to put aside the confidence, and I would like to ask the judge in Israel to be more sensitive to confident people or confident witnesses, as opposed to people who are just naturally less confident, as opposed to actually finding problems in his memory of the event.
May I add to what Neely just asked? By the way, Neely is from the Attorney General's office in charge of legislation and consulting on issues of criminal law, criminal procedure. Some of the things that you mentioned, like letting the witness read the testimony in the police that he gave 2 years ago, I think are clearly things that will increase his confidence, but maybe less change his memory, maybe, I don't know. But another aspect of this interview or preparation is asking the witness, what if? What if I would say someone else was in the scene and did that and that? And this is allowed according to the guideline, and this is especially allowed because the prosecutor knows that someone says that. Yes, it's the what if doesn't come up from the prosecutor's head, but they want to see how the witness will react to questions that might come when the defense attorney usually would confront the witness with such questions. And I don't know, you probably know better, but maybe that might affect memory more. I don't know.
Well, okay. So on the first part, before we get to, on the first part, assuming that what the witness initially said, and that's in a police report, assuming that that's accurate, then if a year or two later you are showing that to a witness and reminding them that this is what you said shortly after the event, probably that's just going to kind of reinstate some accurate information, assuming it's accurate, and they can feel they, maybe are remembering it a little bit better because you've basically reintroduced the truth. If it's not accurate, then if what they said is not accurate and you're reminding them of what they said, then it's going to reintroduce an inaccuracy. And that's going to become their memory. We've actually even published some papers on, under the topic that we call memory blindness, where we tell people that earlier they said something that they didn't really say. Earlier they had said the bad guy's jacket was green, and we now tell them, initially you told us that the jacket was brown. I want to ask you some more questions about it. And you get people to now think that their memory is brown. So it really just depends on whether that thing you're showing them is accurate or not. And now as to your other point, well, I don't know what is your concern with this general statement that the what if,
that is suggestive. I'm concerned that the witness didn't say that in his or her testimony or in the police, and now he or she is confronted with additional information that come from another source. Now, as I said, the prosecutor is not allowed to tell him, Danny said that there was a third person in the scene, okay? But the prosecutor is allowed to say, what if someone would say that there was a third person in the scene? What would you say about that? And I don't know if that's suggestive or not. That's a question, basically. Is it?
I guess, it certainly might depend on how the witness is interpreting that what if. If the witness hears that as another witness says this happened, that's post-event suggestion. And the witness might, you know, who knows, might say, well, there might have been another person there. Or maybe the witness will reject the post-event information, say, no way there could have been another person there. The room was too small or whatever. I mean, so I guess you'd want to know whether they are accepting the what if or rejecting it.
Okay. And last, I think, if I'm not mistaken, last but not least, Tali Gal. Tali, are you there? I thought I saw Tali. Wait. I'll do it. I'll find it somewhere because probably it's a problem of unmuting. You can unmute yourself now, I think.
Oh, yes. Yeah, can you hear me?
Yes.
Thank you. Hi, thank you, Art. I don't have a question. I just wanted to thank you. My name is Tali Gal. I'm from the University of Haifa. Just wanted to thank you for a fascinating talk. And especially for your courageous sharing with us the personal aspect, you know, the price that you pay for stepping up and saying things that are not very popular in various arenas. So I just wanted to thank you especially for that, especially at 5 a.m. in the morning.
Thank you. Thank you.
Yes, so thank you so much. And I want to thank my partners, Anat and Meital. I can't see her right now, but if she can spotlight herself, that would be great. From the Defense Attorney Office and from the District Attorney Office, I want to thank Justice Danziger, who was with us, Rich, who made this event possible, Yaniv, who initiated the idea, and of course, more than anyone else, I want to thank you, Beth, for a wonderful, wonderful talk. It was really, really enriching. I think we learned a lot from it. And
great, thank you.
Thank you so much, and good morning.
Okay, good. All right, bye, everyone.
Thank you.
Bye.